Remember the Voting Rights Act? Big part of the civil rights movement, you know? Big win, big dub, huge dub. We're not going to have it anymore. Yeah, they're taking out a big one. Not the first piece of, like, critical civil rights legislation from the 1960s that this Supreme Court has taken under.
The conservative-dominated Supreme Court appears ready to make it much easier for President Trump and Republicans to keep their grip on power in Washington in maintaining control of the House. So you, of course, have been following what's been going on with redistricting in Texas, the reaction to that in blue states like California. Well, today, the court is reconsidering a central pillar of the Voting Rights Act. That is, of course, the landmark civil rights era law that was aimed at protecting the vote of every American, regardless of skin color. The issue,
woke.
Louisiana's new congressional map. A group of non-black voters say that the state racially discriminated when it created a second black majority district. In oral arguments today, the court's conservative majority seemed to indicate they're inclined to agree.
This court cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have a...
The Voting Rights Act, in addition to some other stuff, requires people of like groups, like racial categories, to be given their own districts with an effort or with an attempt to achieve proportional representation in the voting maps. Or to put it another way, if you have a state that is 30% black and 70% white, okay? The idea is basically you should not be able to create voting districts that carve out tiny portions of the black community into every white majority district, which then ensures a all-white voting result. Essentially, the reason this was a part of the Voting Rights Act was, of course, because this happened literally all the time, especially in the South, which has like a larger black population proportionally. The idea being like, we need this in order to prevent racist state legislatures from ensuring that there is effectively no voice or representation for the black people in these states. And unfortunately, because it is really difficult to draw impartial districting maps, you know, the Voting Rights Act has often led to some like wacky decisions about how to create districts, you know? Like it feels weird to say, no, we have to draw this district this shape because we need to keep the black people in it. So the black people have a district, you know? In practice, there are a bunch of ways to pan it out, but the elimination of this rule basically gets rid of the number one impediment Republicans have, the main obstacle that stands between them and just full-on fucking gerrymandering everything. It was the last real barrier. Here is an image put out by the Senate Judiciary Democrats, current map of the South, and a plausible redistricting scenario without Section 2 of the Voting Rights Act. Without the obligation to not break up and crack all of these majority-minority districts, there's basically nothing stopping you from doing permanent, just unbelievably unrepresentative districting. You could have states that are like 55% Republican for the national vote, but basically, or all of their districts produced Republican congressmen, you know? Not great.
Endpoint. And what exactly do you think the endpoint should be, or how would we know for the intentional use of race to create districts?
So the court may soon effectively forbid states from considering race when they draw their congressional district maps. And that would allow Republican-controlled legislatures across the country to potentially eliminate majority-minority districts, many of which currently held by Democrats. This is, of course, just one piece of the battle in this nationwide war for control of the House. Republicans...
Can't Dems do the same? Right now, no. Dems do not have the ability to engage in the same kind of like maximalist redistricting that Republicans can. There are a bunch of, neutral state districting committees that they would have to override. And even then, I don't even know if they could get the same ground there. I don't know if they'd be able to achieve the same results. I don't know if the apportionment of these of these congressional seats would allow them to.
Hold the chamber by an incredibly slim margin, just 5 seats. Every district matters, and that helps explain why former President Barack Obama out with this new ad supporting California Governor Gavin Newsom's redistricting plan. In less than 3 weeks, Californians will vote on whether to temporarily adopt a new map that is likely to give Democrats 5 more representatives in Congress.
California, the whole nation is counting on you. Democracy is on the ballot November 4th. Republicans want to steal enough seats in Congress to rig the next election and wield unchecked power for 2 more years. With Prop 50, you can stop Republicans in their tracks.
All right, let's get off the sidelines and head into the arena. Our panel is here, along with someone who was inside court during those arguments. That is CNN Chief Supreme Court Analyst Joan Biskupic. Joan, let me start with you. What did you get the sense that, I realize this can be misleading sometimes. We can listen to the justices. You think they're going to decide one way, they go the other way. But what were your takeaways from today?
Okay, good to see you. And it was an intense 2.5 hours of arguments. And, this is the greatest challenge to the Voting Rights Act that we've had up here in a decade. And one of the key questions is whether they will end race-based redistricting as a remedy to voting districts for Congress or for state legislatures that have been drawn to really minimize the electoral power of blacks and Hispanics. You know about that phrase, Casey, of packing and cracking. What Louisiana was found to have done in this case that started this whole thing is to have packed blacks into a single district and then spread them out, cracked them among others so that even though the state has a 1/3 black population, they ended up with just 1 black majority district, and it was lower court judges had found likely violated the Voting Rights Act and required the state to draw a second black majority district. And that's what's at issue here is whether
shit like this makes me think that voting districts shouldn't even be a thing. I don't know. It seems like or either that or computers should do it. Like you need a system where there's no political incentive or motive going into the drawing of these maps. And even then, it has to keep being done. Yeah, get Grok to do it. I don't know.
Was a unconstitutional racial gerrymander. Now, let me just tell you about where I think the justices are going. The most serious ruling here, Casey, would be if they said that states would no longer be required to have race-based redistricting to remedy these districts. It's not, to start out, it's to remedy a discriminatory district. But they have a couple different off-ramps. And I have to say, just listening intensely to Justice Kavanaugh, who was a swing vote 2 years ago in a similar Alabama case, this one's from Louisiana, and listening to the Chief Justice John Roberts, who has really been the leader on racial remedies, that I think they might take a bit of an off-ramp in a way that could still undercut the Voting Rights Act, but not completely dismantle it, as this case.
The Louisiana attorneys were literally arguing that, yeah, the state has an interest to be partisan towards Republicans. A race to the bottom. We're all trying to get down there as quickly as possible, but I don't think the Democrats can match the pace. No matter what happens with the Republican Party and its popularity, I worry one of the big, dead country flags we're getting is the fact that the legislature has been completely non-functional since 2012. Maybe 2010. Yeah, 2010. Ever since 2010. Ever since Mitch McConnell decided my only goal in life is to prevent Obama from doing anything. That was pretty much it. Since then, Congress has not done anything. The only way to get anything through Congress is to make it a rider onto a budget bill. That's it. And the only reason these budget bills get put through is because we just rely on the previous budget bill. We don't even, we make modifications to existing budget bills. Nobody's passed a new budget in a long time, like a full, cut from the cloth new budget. Nobody's done that in decades. Nothing else goes through.
was teed up to, because you played that great soundbite from Justice Kavanaugh at the top asking about durational limits. You know, shouldn't race-based redistricting end in the same way that, college affirmative action has had to end, as race-based school integration plans have had to end? And what the lawyer at the lectern representing the NAACP Legal Defense Fund, Janae Nelson, said...
If this continues, then the Congress will become as irrelevant to the Senate in Rome. Yeah, but the Congress is also just going to remain Republican. The way the Senate is structured is already biased in favor of Republicans because of the... there are more states with lower population and lower IQ residents than there are states with high population and higher IQ residents. But likewise, with this redistricting bullshit, the House might also suffer a similar fate. And the Democrats lost the last popular vote. So fuck, who knows?
This is a whole different kind of law. This is only to remedy situations where we've already shown that there's discrimination. And, that she tried to draw a line for why this case was different. And I have to say, Casey, the liberal justices picked up on that and also seem to be trying to make their case to Justice Kavanaugh. They will vote in their private conference on Friday, and we will know some months from now where they end up ruling.
All right, Joan Biskupik getting us started. Joan, thank you very much for that. And our panel is here in the arena. Professor of Constitutional Law and Global Health Policy at Georgetown University, Michelle Goodwin. Staff writer.
I can't believe one of the most scathing quotes about conservatism came from George Wallace. From this point on, Wallace adopted a wavering segregationist policy. Quote, I tried to talk about good roads and good schools and all these things that have been part of my career and nobody listened. Then I began talking about N-words and they stomped the floor. Yeah, that sounds about right. We should have never stopped with Reconstruction. We should have kept it going. We should have done Reconstruction to the point where nowadays, today, even woke people are like, I feel like, reading about it in the history books makes my tummy hurt.
At the Atlantic, Tolu Olorunnipa, CNN special correspondent Jamie Gangel, former Democratic congressman from New York, Max Rose, and Republican strategist Brad Todd. On the left side of the screen,
always
so
with
this
Brad
was
fucking
not enough,
Todd.
You will see our arena text chain sharing additional analysis. Want to thank them.
I'm not the text chain. Oh my god, give me low rent fucking. Why is my keyboard not working? I'm hitting escape. Let me out. Wait, why is my keyboard not working? Hello? There we go. Fucking wireless keyboards, man. Just, I want to hear the end of the argument, okay?
Congress included a durational limit in Section 5 of the Voting Rights Act. It created a mechanism for reauthorization. It decidedly did not do that in Section 2.
The issue, as you know, is that this court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint. And what exactly do you think the endpoint should be, or how would we know for the intentional use of race to create districts?
Well, Justice Kavanaugh, you raised a very important distinction, and that's between remedies and the statute. So a race-based remedy can and should and usually does have a time limit and a durational limit. Section 2 court-ordered remedies have a time limit. And so that is something that is grounded in our case law. What is not grounded in case law is the idea that an entire statute should somehow dissolve simply because race may be an element of the remedy. So for example, this case has affirmed Title VII. It has affirmed Section 1982, the Family Medical Leave Act, and also Section 4E of the Voting Rights Act.
Why is there no video? No one can record inside the chamber.
In Katzenbach versus Morgan, and never has it suggested that any of those statutes should dissolve in and of themselves, as opposed to the remedy.
I'm sorry to interrupt. I don't think it's the statute. It's the particular application of the statute that entails the intentional, deliberate use of race to sort people into different districts. that particular aspect, I'm guessing, I'm asking what you think the time limit on that should be, or there really shouldn't be a time limit. I think you might be saying there shouldn't be a time limit unless Congress chooses one.
I am saying that. I'm saying there should not be a time limit, but I also think it's critical to emphasize that Section 2 does not require a race-based remedy in all circumstances.
Is that because,
Can I ask,
is that,
I just wanted to follow up on Justice Kavanaugh's question. What if this is an exercise of Congress's enforcement power? If we're looking at the City of Bernie test and we're saying it has to be congruent and proportional, would that affect your answer to Justice Kavanaugh's question, that if it's going above and beyond what the 15th Amendment requires of its own force, but Congress has actually chosen the Voting Rights Act as a remedy, does that affect the question of whether it can go on indefinitely or not, that at some point it becomes not congruent and proportional?
No, I don't think it does. First, Bernie should not apply to Section 2.
I just assuming that
it
my
does.
question is.
Sure. Assuming that it does, as you know, in Bernie, this court held up the Voting Rights Act as the paradigmatic example of congruence and proportionality. The fact that the Voting Rights Act at times may require a race-based remedy does not change the fact that Congress, with its enlarged powers as defined by Ex parte Virginia and the line of cases forward, can address conduct that is beyond what the 15th Amendment addresses. It doesn't need to simply parrot the 15th Amendment. It can address conduct that is even considered constitutional in order to ensure that race discrimination in voting does not go undetected, uncorrected, or undeterred, in the words of the Senate report supporting the 1982
Nelson, I guess I
amendments.
wonder if it would be helpful, at least as I'm thinking about it, because I think this is a very important question. To understand, I think, that you're saying that Section 2 is not a remedy in and of itself. It is the mechanism by which the law determines whether a remedy is necessary.
That's absolutely correct.
So it's a law that is just encouraging or requiring a check-in. It's like a tool. It's like a tape measure that we're looking as to whether or not.
The thing I'm curious about is that the most radical version of the Supreme Court's ruling in their favor would essentially be a de facto abolition of Section 2. But I don't know how well they'd be able to commit to that or how much they'd be willing to. And if they went for anything lighter, like a challenge to its standard of comparison, I feel like it would just lead to a bunch of lawsuits over redistricting that would have happened anyway. I wonder how much, unless they go full hog, I feel like they're just opening themselves up to the same kind of litigation that has been happening and would have been happening anyway. The Republicans in the court will need to just abolish Section 2 then. And if they do, that's very, very bad. But that would also be such a maximal approach, you know?
I don't understand why your answer to Justice Kagan's question about.
This feels like a nothing burger, TBH. No! It's a challenge to a key portion of the Voting Rights Act. It's an incentive on their part to be maximal in their challenge to it.
Is this a compelling state interest? Is no. The answer is obviously yes, that you have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too far in your remedy is another issue, right?
Your Honor, I think step zero in all of these cases, it was certainly step zero in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second
No,
majority
it's
black
not,
district.
because that, again, just trust me on this. The second electoral or second district is a remedy that one could offer for a problem that we've identified. And the whole Robinson litigation was about identifying the problem. Is this really happening? In many, many Section 2 cases, the court says, you're wrong, you're fine. There is not an electoral opportunity being denied to you, go away. In this case, the court said, I see. I'm looking at the factors. I appreciate what you're saying. You've proven that we have this problem. And so the next question is, how do we go about remedying it?
Yeah, okay. Well, I mean, I know how Jackson's going to rule on this. All right, I suppose we'll see. I suppose we'll see. It does seem like they, from their perspective, they wouldn't be, oh my God. They wouldn't be accomplishing very much